Good morning, everyone. From today onwards, we will start a new series. Read with me, Vision IAS magazine. So, let's start with the latest magazine of September 2022. Let's start with the first article in September 2022 magazine. From the first topic, it is Polity and Governance. Criminal Procedure Identification Rules 2022. Why in news? Ministry of Home Affairs notified the Criminal Procedure Identification Rules 2022 governing the Criminal Procedure Act CPA 2022, which was passed in March this year. About Criminal Procedure Identification Rules 2022. 2022 rules specifies the details of CPA in order to lay down the procedure for taking measurements of the convicts and other persons for the purposes of identification and investigation in the criminal matters to preserve the records. Key features of this rule. Taking measurements. The rules specify that for certain purpose, measurements will not be taken unless they have charged or arrested in connection with any other offense. Authorized persons to take measurements. The rule specifies that authorized user or any other person skilled in taking measurements or registered medical practitioners or any person authorized in this behalf may take such measurements. Rule-making power to National Crime Records Bureau. NCRB under MHA will direct states on how to collect and store information. Punishment. Any act of unauthorized access, distribution or sharing of data collected under the Act shall be punishable as per the provisions of Indian Penal Code 1860 and the Information Technology Act 2000. About the Criminal Procedure Identification Act 2022. The Act is repealed in Identification of Prisoners Act 1920, which was enacted to authorize the taking of measurements and photographs of convicts and other persons. 2022 Act expands the scope and ambit of the measurements which can be taken under the provisions of law. It will help in unique identification of a person involved in any crime and will assist the investigating agencies in solving the criminal case. Key provisions of 2022 Act. It expands the ambit of certain provisions. The Act expands the type of data called as measurements that may be collected, persons from whom such data may be collected, the authority that may authorize such collection and the rule-making power. Retention of details. Act requires the details collected to be retained in a digital electronic form for 75 years from the date of collection. The record may be destroyed in case of persons who have not been previously convicted, who are released without trial, discharged or acquitted by the court. Resistance to giving details. Resistance or refusal to give details will be considered an offense under the Indian Penal Code 1860. The role of National Crime Records Bureau (NCRB). The Act empowers NCRB to collect the details about the persons covered in the Act from the state governments, union territory administrations, or other law enforcement agencies. Other functions of NCRB under the bill includes storing, processing, disseminating, and destroying those of the details. The comparison of key provisions between 1920 Act to 2022 Act. First, 1920 Act. Data permitted to be collected are fingerprints, footprints, impressions, and photographs. And changes in 2022 acts are add-ons to the above list like biological samples and their analysis, iris and retina scan, behavioral attributes including signature and handwriting, examination under the section 53 and 53A of CRPC includes blood, semen, hair sample, and swabs and analyses such as DNA profiling. Second parameter, the person whose data may be collected. Earlier, convicted or arrested for offences punishable with rigorous imprisonment of 1 year or more, person ordered to give security for good behavior or maintaining peace, magistrate may order in other cases collection from any arrested person to aid the criminal investigation. Now, in 2022 Act, the convicted or arrested for any offence, however, biological sample may be taken forcibly only from the person arrested for the offence against a woman or a child, or if the offence carries minimum 7 years of punishment. The person detained under any preventive detention law on the order of magistrate from any person, not just an arrested person, to aid the investigation. Next parameter is the person who may require direct collection of data. Earlier, it was investigating officer under CRPC, officer in charge of the police station or sub-rank inspector or above, and magistrate. Now, the officer in charge of police station or the rank head constable or above, head warden of the prison, metropolitan magistrate or judicial magistrate of first class, executive magistrate in this case of persons required to maintain a good behavior or peace. Rule-making power with regard to the manners of collecting details. It is vested in state government. Now it is vested in the state as well as central government. Key concerns with the Act. It may violate the right to privacy. The information specified under the Act forms the part of personal data of individuals, and several provisions may not meet the necessity and proportionality standards laid out by Supreme Court in 2017, amounting to the forcible extraction. The Act attaches criminal liability for resistance or refusal to allow taking such a measurements. Such criminalization in the violation of individual right against the self-incrimination under Article 20.3. It heightens the possibility of misuse. Act allows the measurement to be taken if the person has been convicted, arrested for any offense including petty offenses. Further, there is no limitation on the use of data collected. Such discretion is likely to result in the abuse of law at lower levels and overburdening of the system used for the collection and storage. Such collection can also result in the mass surveillance, with the database under the law being combined with other databases such as those of crime and criminal tracking network systems. Limitations of NCRB. NCRB is ill-equipped to deal with the quality management for database containing records of the proposed measurements, particularly of biological sample and their analysis. Predictive policing. The inclusion of derivative data such as analysis and behavioral attributes have raised concerns that data processing may go beyond the recording of core measurement for predictive policing. Provisions that may not meet the standards laid out by Supreme Court in Puttaswamy case. Storage in central database which can be accessed widely and not just in the case file. Safeguards have been diluted by lowering the level of official authorized to collect data, and data is stored for 75 years, effectively for life. Need of CPA 2022. First, to make provisions for modern techniques to capture, record appropriate body measurements in place of existing limited measurements. To make the investigation of crime more efficient and expeditious while increasing conviction rate. And previous recommendation. First, in 2003, Mallimath Committee recommended amending 1920 Act to empower magistrates to authorize the collection of data such as blood samples for DNA, hair, saliva, and semen. In 1980, the Law Commission of India noted that the need to revise 1920 Act to bring in line with the modern trends in criminal investigation. Concerns with the notified rules. The rules restricting the grounds under which the person's data may be collected. Rules do not define who is the person skilled in taking measurements, while expanding the list of persons who may take measurements. Excessive delegation of rule-making power to NCRB may violate the principle of separation of rules between the entity that issues guidelines and entity that has to follow such guidelines. The records to be destroyed on request. To destroy any record, a request has to be made to the nodal officer. While Act empowers NCRB for summon to destruction of records, the rules put the onus on the individual to request for such a destruction. Conclusion. The 2022 Act is a welcome piece of legislation which is targeted towards the advanced prisoner